Good morning, Christina.
Good morning.
Thank you for joining us this morning. And it was quickly organized, but I'm very excited about what we're going to be talking about. So I think just introduce yourself and who you are, where you're from, and then we'll get to why we've got you here.
Hi, good morning. So I'm Christine van Zyl. I'm an attorney. We recently opened a branch, TGB Attorneys, in Kenridge, Durbanville. TGB Attorneys has its main branches in Johannesburg, and the main director has been practicing there for 45 years. So I'm manning the new office here in Kenridge. So my background, I've got a BSc Medical Sciences background, which I did at UP, and I did a postgrad law degree, and I obviously worked in commercial. I did commercial law for a few years. And interesting enough, I worked for NGOs as well. So, and during my work for NGOs, I did some parliamentary work as well. So I've got I always feel I'm a bit of a jack of all trades. But because I'm a bit of a jack of all trades, I've seen where the overlap is and the need is, for instance, when it comes to legislative instruments, understanding it and the need. So I've seen exactly where the public needs to be more involved and how it impacts contracts. And yes, it's been my interest. So currently, getting back to a discussion of today, I'm enrolled for LLM, a master's degree in intellectual property at Stellenbosch. So my focus is intellectual property rights.
Okay.
Wow.
That's a
That's
lot.
quite a mouthful. It's like, where do you go from here?
You really like studying.
Yes, well, you have to. My dad is also an attorney, and he initially said to me, when I said to him, I've always wanted to do law. He said, no, but you have to be, you have to specialize a bit more because it's don't just do law. And I've always loved science, so it's always been but I knew I didn't want to be a doctor. You just specifically know if you're not called to be a doctor. So that's my background.
So you went to study to be a doctor initially?
No, never. No, I did it. I knew I just wanted to do a BSc, and I knew I would eventually do law. So it was just an additional. I don't want to say an additional degree. my dad did say to me, "Sure, are you sure? It's a lot." But I enjoyed it. I really enjoyed it, and it's been. I do find there's an overlap in the way you approach a problem. I do think my BSc background has given me, a way I address a problem. I would always physically draw it, and just understanding it, the bigger picture. I think that's where the science background comes in. So getting into the agricultural sector hasn't been such a big leap from, my background in it.
It's interesting because with all the things and the people we get to meet, you find these things that if you would go to high school and you would ask a matric pupil now, what do you want to be one day? And they say, I want to be an attorney.
Yeah.
They would never connect agriculture and an attorney. They think standing in front of a court fighting.
No, that's actually very true. I mean, they expect you to, there isn't any specific subjects even for if you law. You don't need science or biology. That was actually my strong subjects and at school. But luckily, the field of law is ever changing, and I think you have to also adapt. And considering artificial intelligence, especially, you have to use it. You have to use it properly. Nowadays, you can get AI to create a contract for you. So, but it doesn't mean it's a good contract. You need a speciality. You need to be able to use and manipulate. No, I wouldn't say manipulate AI, but be in control of AI.
No, but it gives you the skeleton you can put the flesh on.
So going, in the future, I think if my advice to any matric student ever considering law is, see, you have to specialize. You have to think broader how the world will change and use it. Just law is it's a very nifty tool, but you have to widen your perspective.
Do you struggle to get beautiful photographs of fresh produce? Visit our stock site. We've got gorgeous photographs of all kinds of fresh produce.
Indeed. So how did we end up sitting around a table chatting to each other? So just to say, you sent me something very interesting on LinkedIn about plant breeders' rights, and you certainly piqued my interest. So please tell us a little bit more about how you got into that, and then the topic on the table today.
And the reason it's so interesting is because we do work a lot with different breeders from all over.
Yes.
with various different things. So these royalty rights and all this has always been interesting to us, and to me in particular. So to get more of a legal insight, because you'll go onto one of these groups on Facebook, Tannies vir Tuinmaak or something like that, and somebody will post a picture of, let's say, sweet sapphire grapes, which looks unique, and then everybody says, where can I get a cutting? Waar kan ek 'n stiggie kry? So
No.
and to try to educate the man on the street about all these things is quite a thing.
Yeah, no, you point out it's a very good point. Plant breeders' rights is a very, very specific field of intellectual property rights. So you also get patents, for instance, copyright, which you obviously know of, and trademarks. So it's a small area of plant breeders of intellectual property rights regime. But as you say, once you start looking into it, it's a massive, massive, massive sector, and it's especially in South Africa, where the agricultural sector is growing, foreign breeders are very much interested in what's going on and are keen to invest in our country. So getting back to your question, Louise, how did I get into plant breeders' rights? So
tell us about why it's so important.
Why? Okay. So the last few years, I've been assisting an agricultural client, and due to my background in Parliament, I knew how, inner workings of legislative drafting, which I think not a lot of attorneys actually, it's a field we do at varsity, but there's a lot of legal aspects to it, the process itself. So I was I did have a specific background in how it works, and I worked for this an agricultural sector. And during the time, draft regulations were published on the Plant Breeders' Rights Act of 2018. So let me just stop here a second. So we currently have the new Plant Breeders' Rights Act of 2018. So it regulates and manages how to apply for a plant breeder's right. So that is your intellectual property right associated with a new variety in South Africa. So we used to have a Plant Breeders' Rights Act of 1976, and the new Plant Breeders' Rights Act of 2018 replaces and repeals the 1976 Act. So this 2018 Act just recently came into operation, literally the 1st of June.
So like right now?
Literally 1st of June, yeah. But what's interesting, it's actually what you often find in law, it's such a long process. That bill, so that's your predecessor to any act, was already introduced in Parliament in 2015. So you had your whole public participation process, etc. in Parliament. It was passed by Parliament in 2018 already. And I mean, that's already a few years back. So what happens when it's passed in Parliament? It's sent to a president to send to. So he effectively, it means he needs to sign it. And it doesn't mean it always comes into operational date. He signs it. There's normally a provision in the Act. And in this instance, it said, the Minister of Agriculture will decide when this Act comes into operation. So you had an Act which was signed in 2019. So it has legislative effect. It has legal effect in the sense that it can be challenged, but hasn't come into operation yet. So it's a bit of a weird situation. Yeah. It hasn't come in operation yet because your regulations, which are like a physical, it's a detail of how the Act is to operate. For instance, how to apply for a Plant Breeders' Right Act, Plant Breeders' Right. That's, for instance, in your regulations. Duration for a Plant Breeders' Right. That's, for instance, in your regulations. Like all the detail, that's in your regulations. So your regulations and your Act have to come out at the same time. So the regulations weren't obviously yet in place. So I had draft regulations, which I published, and that's how I got involved. We made submissions on these draft regulations. I looked at draft regulations, attended workshops by the department. Now, perhaps just to take a second here, it's often when it comes to regulations, I think your public are not very aware of it. We are aware of controversial bills in Parliament. I mean, because the media writes about it. And even when it comes to acts which are introduced in Parliament, that whole public participation process, I think that's much more, people are much more aware of it than regulations, because regulations are published in the government gazette. And so unless you monitor the government
Yeah.
gazette, you're not going to know.
Exactly.
And department, okay,
Or they will publish it this big in the back of the
Yes.
local newspaper
that you can comment. I mean, that's where you get active. I think that's where it's so important to have active role players from, your private companies, your NGOs monitoring what's going on, and even publish on their own websites and, social media handles. Listen, these regulations have been published, or this is what's happening, because you wouldn't otherwise really know. I mean, the Department of Agriculture is an active, it's really, it's a good web. They have a nice website, but unless you really go into the media, you have to really search. You have to know what you're looking for to see a press release. Okay, so the regulations were published on these Plant Breeders' Right Act of 2018, and that's how I got involved. I considered it. Applied my legal mind to it. What concerns there were for industry and as well, and made submissions. So following the draft regulations or commenting process, the Act itself came into operation now, 1st of June, and the regulations were published shortly afterwards, literally like 2 weeks later, and which technically it should have been published exactly the same time, but we now have the new Plant Breeders' Right Act of 2018 and its regulations in place, which manages and regulates your new regime for how to apply for a plant breeder's right, and etc. So, I know it's a lot. Please just stop me. I think it's quite a technical subject.
Yes.
But every farmer and marketer and exporter, they are very well aware, like you say, like you were referring to die tannies wat nou 'n mooi roos het en kan hulle nie dit sterk vat. They're very aware of the intellectual property that protects her variety, and so it's only the owner of the variety who collects obviously fees called royalties on the commercial use of this plant material. But please stop me if I'm saying I do talk a lot.
No.
So thank you very much for a very good, thorough explanation of that. What piqued my interest in the letter that you sent me was the caveat about farmers' discretion, or what was that term?
Farmers' privilege.
Farmers' privilege. Please explain that and how that can create a little bit of confusion. Let's call it that.
I think you point out that is exactly a sticky part in our legislation. So I think it's a very good aspect to discuss. So farmers' privilege is essentially means, when it comes to, it's a practice of, especially in developing countries such as ours or rest of Africa, and actually I think in most parts of the world, where farmers actually save propagating material. So your voortplantingsmateriaal, your material of your harvest, to replant and reuse, and on their own land, own holding. And so especially here, it's a big practice, and traditional, subsistence farmers do it, household farmers do it, and there's a very fine balancing act between, now you have the specific variety, plant material on the variety, which includes obviously seeds, propagating material, for instance, which is protected, which is, you had a breeder who spent considerable money and resources developing this variety. And he came to South Africa and he registered, he applied for plant breeders' right, was granted here, for instance. I mean, it's a long process. And he was granted, and it's for a specific period, depending on the specific variety. For instance, it could be 25, 30 years now. In terms of the new act, he has protection. He's the only one who can, he can gain commercial gain, can collect commercial royalties of this variety. But now you do have this practice of reusing seeds and etc. And also considering there can't be an endless monopoly on the use of intellectual property, which is always a very fine line. So you have to meet these two very different, how can I say it? What's a good word? You have to balance it out. So how do you realize you have to also protect these farmers who use it? It's not really for commercial gain. They use these literally for food security, to survive, if I can say it like this, as a practice, but it might be protected it might be a protected variety. So it's not a new, we call it colloquially, it's known as farmers' privilege. So it's an exception to a plant breeder's right. So if they meet specific criteria, which I'll go into detail now, they won't be infringing on a plant breeder, on a owner of a plant breeder's right. So they wouldn't be penalized. I mean, and quite in terms of this new act, penalties are quite hefty. That's been a big aspect which I wanted to address. There's disadvantages to it as well, but I think a lot of people in the industry are happy about it. But so penalties are quite hefty. Okay, so getting back to, we not get off track, farmers' privilege. So, and specifically, it's like I say, it's a concept internationally. You have a lot of laws of foreign countries do have it, do provide for it. If there's specifically a farmer who saves seed to use again, but specifically it's limited for its own use, not basically for survival, for its own household use, not to make not for commercial gain. So that has always been during the workshops here and during comment process, it's been a very sensitive topic because obviously we do have a majority of our farming community, our subsistence farmers, smallholder farmers, and where it gets difficult in South Africa, the categories between farmers are very difficult. You have a subsistence farmer who basically just cares for himself, but they also make a little bit of money out of it. Now you have a smallholder farmer. And what's exactly the difference between these categories? Because the last thing you want is a farmer exploiting this provision, this exception, and for commercial gain. I mean, that is exactly not what you want. But where do you, for the department or for us as a country, it was very difficult. Where do you draw the line between a subsistence farmer who makes a little bit of income from what he grows? He sells it in an informal sector. So you can imagine it was a very sensitive topic. Now, sorry do you have a question?
I've got many questions.
Okay, but I don't know if you want to. So I can say how, compared to the draft regulations, how the version we have is better. There's still some issues concerning it, and I do have to give credit to the department to an extent that they actually did listen to stakeholders. But one aspect which hasn't been specifically addressed, which was an issue, is, the use of propagating, saving and using it again. So it's technically, seeds. You don't really, it's not what you don't use in a fruit sector. It's not what you do. Fruit crops, you don't, it's not a practice, which weirdly enough, it was still included. I mean, this aspect was raised very strongly during workshops, but it's still in the final regulations. Fruit crops are still included as a variety, which this exception can apply to. There's obviously limits we will talk to about now of how many plants you can use, how many plants won't, if you etc. plants, it won't infringe a plant breeder's right. So that is a bit of an issue still, and it's also not in line with international. I don't know if I'm sure you know about UPOF. So
I wanted to ask about UPOF and how that affects us and all, because because a lot of the plant breeders' rights are granted from foreign countries for intellectual property development and management in South Africa or Southern Africa or the whole of Africa. And it obviously has to tie in with the international laws. So how does our country's situation...
Before we go there, because I just want to go back to what she's mentioned about the seeds and all that.
Can I please finish my question quickly? And then you can come back, because otherwise we're going to confuse her. Okay. So how does this farmer's privilege affect the international laws? Because you can protect something in a nursery to some extent, but once it's out there, how do you stop farmers from propagating new trees from that? It's a bit of an issue. Sorry, Dewald, but I just want to finish.
Mine almost ties into that because, look, we work predominantly in the fruit industry, so we know how it works. It's cutting and budwood and all that kind of stuff, and it's got to be virus-free and the whole bang shoot. But what about something like wheat or maize? Because I'm pretty sure there will be royalty stuff on that as well.
Yes,
and also soya and other vegetables and things like that, because a cabbage in the shop is not... Two cabbages might be two different varieties. So, for instance, in maize or wheat or soya, where there's a bulk lot of seed, I don't know how the royalties on that work. I roughly know how the royalties on fruit work because there's a per box price that gets exported, that gets paid, it'll price on the tree, and et cetera, et cetera. But for those kind of things, if you take 50 or 100 bags and you stuff them in the back of your shed or behind your tractors and you plant that next year, you can exponentially increase that volume. So how does that kind of stuff get tracked?
So I think, before I
Lots
answer
of
your specific,
lots of questions.
But I think
Sorry.
maybe, I think to a large extent, I think I'll be able to answer it if we go back to how farmer privilege is currently detail regarding it. Because exactly like you say, a small number of seeds can actually cause
Especially in wheat or
Yes.
maize, whatever.
So, like I said before, it's not technically a practice when it comes in the fruit industry, but we have included it in our terms of our regulations. Okay, so the scope of farmers' privilege is actually quite limited. So they firstly provided specific categories of farmers. So we get your household farmer, vulnerable farmer. There's actually two different subsistence farmers. And then you get your smallholder, medium scale, large scale, mega corporate farmer. So all these have specific financial thresholds for the annual turnover, which has been included, which wasn't previously in the draft regulations. So that's already a good step. There's obviously always a little bit of vagueness regarding those terms. But from the get out. Sorry,
That's all good.
Get out. Is that a word? This farmer's privilege cannot be relied on by a medium-scale farmer up to a mega-scale farmer. So they can't rely on it. It specifically says it's not, they can't rely on the draft. The regulations are very, very specific about it. The draft regulations weren't. So that's already a very good first step.
That gets put into the contract what they sign with the breeder when they get the seed.
Yeah, they will know. No, they know if they infringe. Yeah, they will definitely. They know they can't.
But it's got to be on paper somewhere.
Yeah. But this is So always your contract has to be in line with your statutory limitations. But this is, for instance, a farmer who didn't get who isn't in a contract bound and he's using these and now suddenly saying, well, I've got this exception, there's no contract, and you can say, well, I'm relying on this privilege when the breeder notices, but listen, you're using our seeds. They won't be able to rely on it. So it's literally how we actually see it. It is for your very small subsistence farmer. There is a little bit of a grayness when it comes to your smallholder farmer because they are allowed to use it. Okay, they technically have I think an annual. Don't quote me on it now, but I think an annual limit, like an annual turnover, has to be like $1 million. So the smallholder farmer can rely on that specific exception. But now where regulations are very, very specific is the number of each variety. So when it comes to the fruit sector, fruit crops, it used to be, just wrap your mind around it. I just said, it's not common practice. And secondly, the draft regulations, for instance, stated 100 trees. Mm-hmm. Can you imagine how that could be abused? 100 trees, the harvest material of 100 trees. Those were the draft regulations. Sorry for interrupting you, Dewald. No. Now it's been limited to 5 plants. There's also a lot of limitation on it. It has to be grown on their own holding. I try to limit it not for commercial gain. When I say the smallholder farmer, there's a little bit of scope. Then they say you're allowed to. Another controversial aspect is the exchange of propagating material. So that is allowed. I think a lot of industry were saying, please, we do not want, because it's also a bit of a sticky area.
Yeah.
But again, they try to limit on the same, and it's only for propagating purposes. So you're using a material. So say you're using seeds. You're saving X amount of seeds only for your own purposes, for propagating. It's not for any other reason. So it is, I think, it's an area that will have to be tested, but it's definitely much better. I think a department tried to a large extent to listen to industry stakeholders. Now, when it comes to, for instance, the potato industry, they were very well represented at the workshops, and they also number of tubers, I think.
Yeah, tubers. Yeah.
Yes. was also drastically limited to what's allowed now. So I think the department tried to a large extent. It's a balancing act, try to address it as well. And okay, so I hope that answers your question to an extent. Your question about internationally. So we have the International Union of, UPOF, it's International Union of Protection of New Plant Varieties. So
Well done.
we are, yes, sure, that was like a tongue twister. So we did sign the 1978 Act, but there's a recent one, the 1991 Act, it's the latest one. Most, European countries did sign it. Our new act, to a large extent, even though we don't directly say it, tries to mirror the 1991 provisions of UPOF. UPOF has specific explanatory guidance on, they're not going to dictate what member countries have to do, but they'd say, listen, this is how we try to guide you, for instance, on an aspect such as farmers' privilege. And they specifically said in their notes, it shouldn't apply to fruit crops. It doesn't make, it's not a traditional practice. There should be clear limits. So also maybe just to add, so if a farmer, for instance, in a category who is allowed, who doesn't, he fulfills it's in his own holding, a specific variety, and he's in the limits of a farmer's privilege. If he goes over, say, a number of plants or variety he's specifically using, a breeder can come to him. And there's specific conditions for a reasonable payment of royalties can be expected. There's a lot of specific conditions. For instance, he had to get it legitimately. Remember, otherwise it would be a direct infringement penalties, and the penalties are quite hefty. You're looking at 10-year penalty, 10-year criminal penalty. Yeah. For intellectual property rights, that's quite a hefty penalty.
But it's important, isn't it?
It is. It is. I think it needs to be a balance because, you can't have there can't be a monopoly on intellectual property. It's what I say, and that's the beauty of it. There's a limit on how long you can exercise this right.
What is that limit?
Okay, so that's also good. It's been extended, which corresponds to many European countries as well. For most, so it depends on your variety, but if you look at trees, your sugarcane vines, it's about 30 years, which was extended from 25 years, I think, from a last act. So that's good. You've got a very long period where you exercise a right,
Yes.
and then it's an open variety. I think what people have to remember, after this statutory protection in terms of IP, after it expires for that duration, then it's an open variety. Then the breeder people can't ask royalties on this variety anymore.
After 30 years?
Yes, after a duration for. There's also another act which I can't speak much about it. There's a provision for compulsory licenses as well, which the state can give. But I think there always needs to be a fine balance when it comes to intellectual property rights, and there's a lot of different interests you need to protect. I'm sure a copyright bill, which was quite controversial. Also, again, it's balancing a lot of different interests.
Okay.
So I hope I answered. Sorry, it's a lot. I know it's a very technical area, and I think
it's very important, though. It's
interesting.
It's interesting. It's very, very significant for our fruit industry to have new varieties, the sought after ones that have an edge in being better somehow than the other one. And let's face it, there's a lot of money in it. People have to, the intellectual property managers, it's a business. And also for growers to be able to access that stuff, they have to pay for it and they have to look after it and make sure that they don't, that the neighbor doesn't come in the night and steal stackies, sorry to be blunt. There's a reason why people bother with all of this, and that's to get an improved product.
Yes.
So, sorry, the act also, farmers' privilege isn't the only exception to a plant breeder's right, or, there's also, if it's for private use, for instance, or for experimental use, there's but it's very, very limited scope. It basically boils down to non-commercial use. So you're not going to, so obviously you can imagine a breeder wishes to gain all the commercial
I can get a
advantage.
sticking planted in my garden then.
But
Don't go there. Don't talk about it. Don't go there.
It always,
Okay, I've got while you're saying, okay, right, it's for 30 years. Now, let's say there's a very prominent grape or citrus or apple variety, whatever, that's doing very well. So that 30 years, is it from when it was commercialized by the breeder or when it was commercialized in the country that it is in?
Okay, so important aspect of intellectual property rights is always jurisdiction bound, so territory bound. So that's why you need to apply where, if I've got a beautiful variety and I see, okay, it's doing great in Chile, I want to see how it's going to do in China. I have to physically go to the Republic of China, appoint an agent, and I need to apply for a plant variety right, I think it's called, or in our country, obviously plant breeder's right. So it's jurisdiction bound. It starts from when a certificate from the department is given. So there's always a bit of you technically, in terms of the 1976 Act was very specific, well, not very specific about it, but you can't commercialize before you are granted, before you're given a plant breeder's right. Because, and it's very, Act says, okay, you as a holder of a plant breeder's right, you have the following rights. You can, for commercial gain, you can give licenses in terms of this, and you can get remuneration in a form of royalty. So that's a specific right you have as a holder. So normally how it works is the variety will come into a country and it will test and evaluate it first. Okay, that's that period. So that's not a commercial period. It shouldn't be a commercial period. Once PBR is granted, then it's a commercialization happens. So that's a very I think technical aspect, because obviously everyone wants to jump quickly onto a variety, but you have to. There's statutory limitations which you have to adhere to in terms of the Act. I mean, it's a regime which is regulated in terms of statute. You can't say, well, my contract trumps this Act. I think it's also important where contractual rights and has to adhere to your statutory limits.
So that 30 years is from when you get that certificate in that country? Okay.
For instance, our country, it would be now, yes.
Okay. So my next question is, so when that 30 years is done, this variety is coming to South Africa, it's commercialized in 2025. So in 2055, it becomes open. Then anybody can use it to breed or make as many plants as they want, if it is still viable in the industry.
Yeah, technically it's an open variety. I think that's where, and that gets, now you do have, obviously you have a breeder who still wishes to get commercially, it can't be called a royalty and it can't be associated because you have a royalty, you have a intellectual IP on it, because that's not true. You do not have that intellectual property protection anymore. So I think that's perhaps a good point for the public to know when regarding IP and their rights as well. I think there's an expectation, well, it lasts forever. No, there's a statutory limitation to for instance, it's different to trademarks. It can be renewed every 10 years, for instance, but this is not the case with plant breeders' rights, for instance.
So, for instance, and let's call it by its name, Autumn Crisp grapes is trademarked. They do a massive amount of marketing for the brand Autumn Crisp. So after 30 years, technically, if I'm understanding this correct, that becomes in South Africa an open variety.
So I think it's,
but the trademark will still be there.
Yeah,
so there won't be.
So there's two different aspects to it. Obviously, two intellectual property regimes dominating it. You've got your variety, which is protected in terms of our plant breeders' rights system, and then you got your trademarks. So it might still mean that a specific variety is associated with a trademark and needs to specifically meet certain qualifications. So you wouldn't be able to sell that variety under that trademark unless it meets those qualifications. So it's great. You've got so that will be strictly, and that's where they will still get their commercial.
Interesting.
But if
a trademark is often association. I mean, that's a strong. The specific, I mean, you have to really know your variety well to know, okay, this apple doesn't belong to a specific trademark. So just to get that straight, it's two different, your trademark will still, in terms of that agreement, will dominate the commercial terms for use and at least very specific criteria, for instance, in use of trademark. I can't comment on a specific trademark now, obviously, but on a variety, there will be. Yeah, so that's how
Very
how
interesting.
Yes, so that's how they will still
Okay.
get their
I've got another question.
this little
Go.
salt mark.
Another question on the same topic. Right. So in certain plants, apples, pears, citrus, not sure about grapes, you could possibly help me there. You do get mutations
Yeah.
on plants.
Yeah.
And you do get crosses. Like for instance, if you take the seed out of a Granny Smith apple and plant it, that will be a new apple. It won't be a Granny Smith apple that sprouts up there. What do you do then? If I walk in an orchard,
Yeah, that's a very yes. So I have to firstly from an attorney side. I'm not a scientist, even
Yes.
though I've got a BSc background. It's definitely not my field. But so there's specific criteria for a plant breeders' rights testing done. So is testing done by the Plant Breeders' Rights Authority. So you have to look at, I think it's again, don't quote, it's newness. It has to be a uniform, stable, and there's one more, distinguishable. There's very specific phenotype.
yeah.
Ooh, yeah, I can't.
Phenological.
Yes, that's a word. Phenotype is a.
Yeah.
Yes.
Phenological
they
difference.
do-
You'll find the
they
English
do-
word and put it on the
yes.
screen.
So they do very specific testing on it to make sure, and that's where. So I can't comment on it specifically, but it will be very specific regarding these testing and for mutations as well, like you say, which happens obviously. You do get a concept like essentially derived varieties, which is a very technical concept in plant breeders' rights. I have to be very honest, I'm not a scientist, so I won't be able to give you a specific detail regarding that. But to give you an idea, there's a lot of testing done. And I think it's also, I mean, reality is mutations do happen, but I think a degree, they've got very specific criteria they look at, and these are the specific,
And for those that know that if you do find a mutation in an orchard or wherever, it takes about 10 to 12 years before that could even become commercial, because you've got to go through all of this testing. And,
normally a contract would specifically address any mutations. But again, I can't speak to specific contracts, but your contract would have because it does happen, obviously,
Yes.
and you would need to alert a breeder immediately. Normally that's a specific aspect.
We've spoken about a lot of incredibly interesting and technical things, but I want to ask you something in a very simplistic way, so that because we've dived deep into some technical stuff. So the new legislation that has come into effect now from the beginning of June, do you see that as an improvement on what we had previously? That's part of the question. And are there any challenges that plant breeders, South African plant breeder protectors, like the IP protectors, need to just keep a lookout for? Are there any challenges?
That's a good question. Yes, in certain aspects, I mean, it is aligned, the extension of the duration of a plant breeder's rights. That's, for instance, a good aspect. It's aligned with a lot of foreign countries as well, and a breeder will be happy about it. I think a penalty provision is also, it's a deterrent for any infringement. So a foreign breeder might feel like, okay, investing in this country would be, we've got a very specific political scenario, so they need to know we've got a strong legislative framework. So, and we do. Enforcement is obviously always a problem, but we do have a very strong legislative framework. I think aspects like this farmer's privilege is a bit, is a bit vague in certain terms. We'll need to see how it rolls out. Another aspect which I can't comment so much on, which is a bit of it's aligned with UPOF, but there isn't much on the topic, is the idea of exhaustion of your plant breeder's right, your exhaustion of IP. So that's also an interesting aspect, which I think might be challenging, and also it would actually be very nice if the department could give you insight, guidance on how this should be applied, because you don't often find case law. That's often when it comes how legislation on interpretation. It's often in case law. Like, you go to court, parties have different, how a specific provision is interpreted. And case law will say, okay, listen, this is how it should be. And it takes very long for amendments to be made to legislation. If it's not due to case law, for a minister to reintroduce it, go through a whole parliamentary process again. So my point being is you don't often see case law regarding plant breeders' rights. It's a very specific field. So I do think there's vagueness, specifically when it comes to farmers' privilege might be vague. This aspect of exhaustion of rights might also be it's unknown a bit. It makes sense in our fields of IP. It's difficult to see how it's going to be, but it's aligned with UPOF specifically has those provisions, but you need guidance on how it would be interpreted. I hope I gave you some.
No, that's great. I think you gave a very good answer.
Another
Thank you.
aspect, which also this is very technical, is when plant material has to be provided to a plant breeders' rights authority. It used to be, I think, 24 months, and now there's specific provisions and extension of. So that might be also a big aspect stakeholders need to take into account. Because that's often a problem. How to get plant material in for a department to do for a plant breeders' right authority to do testing on.
Okay.
Yes.
So-
Sorry, it's a lot of
No.
information.
I asked the
think it's-
question
I
and
think
you
it's a-
gave a very
it's
good answer.
It's a very technical field, but I do think it's very good for the public to be aware of IP and to know their rights as well.
I was about to actually ask you to expand on that a little bit. So people know about IP. If you addressing the South African,
the South African farmers know about IP, but
they do.
the general public out there knows nothing about IP on fruit.
Exactly.
Or-
So
I
if
didn't
you
know so much about it. I was also quite. I mean, sorry for interrupting you. I had IP as a during university. I did it, but I mean, you don't realize to what extent it's applied and how it's a huge field in the fruit sector. And what's actually quite sad is when it comes to smallholder farmers, they do not know much about IP. There's been a lot of studies done, and they actually went out and took census. Ask if subsistence farmers, do they know what it means? Like, this variety is protected. Someone spent considerable resources to develop it. There's very, very, very little knowledge on it, and I think that's exactly where we need to focus. Also, assisting. I think we're so focused on protecting IP, which is it's obviously very important, but also assisting smallholder farmers. I mean, and that's much bigger than an IP question. It's just knowledge on and how to get access into the market. I think it's a very it's not my field, but I think it's such an important aspect we need to address in our country, because I mean, agriculture it's dis die agterbeen. Wat is die backbeen?
Ja, no,
Dit is die literally translate. Dit het nou verskriklik geklink.
It's the
Dit is die
backbone of our
backbone,
country.
and it is. I mean,
You kind of addressed part of the question I want to ask you, but maybe you want to just go there more specifically.
Okay.
So, as we discussed now, IP is there. It's important.
Yeah.
It's very significant to giving people the edge, and it's a big business. If you were to speak to the general public, what would you say to them about IP within agriculture? Like, have you got a message to people about the value and importance of IP in agriculture, and maybe telling people about it? Kind of went there, but I'm asking you straight on.
sure, that's I think we need to, the emphasis would be for me is we need to get foreign investment in our country. I mean, it has a direct knock-on effect growing up for employment opportunities, etc. So we need to make it lucrative. And and that's why I think IP is such a important field. A good IP protection and reporting infringements and making sure your contracts are on good order as well, and providing that protection. That's why I think it's so, for a broader, say, agricultural community, we want investment. And a big aspect is making sure IP is well protected. The foreign breeders will be, okay, my IP is well protected here. I'm going to come, I can release my variety here. I do not want a neighbor to come and steal it. And, so that protection is, so for me, I hope it answers your question to an extent. That's why I think IP is so important for a normal, I wouldn't say normal public, but the general man on the street to know about. Is we want to attract investment in our country. We always say we want to stimulate our economy. We want to do and this is a big aspect of how we can do it. Agricultural innovations, I mean, it's amazing. And the varieties being developed, it's obviously taken into account climate change and what's happening in the world. It's so critical for investment purposes.
I want to tie onto that. Put the shoe on the other foot. you're talking about foreign investment, but why can't we in South Africa breed our own varieties? And I know there's a couple of South African varieties that's gone into the world that's doing very well, but equally, it doesn't just have to be people in America or Europe or wherever that breeds these things. It could be us. It could be us that does it here, and have that money coming to South Africa by people in other countries using our what's been done
and
here.
people who invest by buying our IP, which has just happened in the last while.
Yes.
That we have had some big investment coming in and buying South African IP, which is going to be used internationally. So it's good to know, and it's also good to know that when infringements are reported, they can be prosecuted in our country, and it has happened. So it's good to know that that's in place as well.
That could also, maybe you've got a message for a grower that's investigating a new mutation he's found or new variety he's happened to just stumble upon, or that he's actually put effort into breeding. What kind of advice do you have for somebody like that?
Sure. From a legal side, I think from a get-go, know your protection well. I mean, know your IP, know what you're allowed to do. I think it's also, that's actually a difficult, my specific advice, which got me now. I would also love to see breeders, our local breeders, you stumbled on a big point, and we need to ensure our facilities are to that extent we can't compete. I mean, it's great having a territorial-based climate for all these foreign breeders, but we also need to ensure, and I think that's where the department also needs to see how it can assist and what it can do. So my advice would be is to work with the department, work with knowledgeable people. I mean, the universities you have so many unbelievable researchers in this industry. I mean, in my little experience, it's unbelievable how many people actually do know so much and will be willing to help and assist. And I think that's a testimony to our country. Again, people want to see a smallholder farmer do well. We all want to. So I think it might be finding a network, finding a correct network, finding a correct person to assist, and specifically in that field.
Because if you look at...
Did I answer you?
Yeah, I think so.
It's a very broad answer, but hopefully it narrowed it down.
If you look at the breeders and the people that let's just take the fruit industry. If you go kick over a couple of bushes in those international companies, you're going to stumble across a South African very quickly.
Yes, very much so.
Very deeply rooted and connected into that company.
Not just Elon.
But no, but they are there. They are there, and they're not. Yeah.
Yes.
No, it's true. It's very true. I think we have such great knowledge bases, and I think it needs to be exploited more. We need to focus more, but I think your universities also are a good starting point as well. What are they doing? Agricultural sector, it's unbelievable. So I'm very positive. I think, and also if you see how it's grown, our exports have grown. It's the statistics are there. It's doing very well.
And youngsters that's keen to get into this, or that might not even know that this opportunity exists to be in. Like you said, there's very little case law that you could even study. Yeah. So that means that one of the things is that it doesn't get infringed much, so that there's very little, which is a good thing.
It's very good thing. Contracts are very well written.
Yeah. But the other thing is also that there might be more hands needed for this, because not many people know about this or are interested in this.
It's also a very small field of IP. It's a very lucrative field of IP, obviously, but it's a very small field of IP. I mean, when you speak of IP, most people are like, oh yes, trademarks, patents. But specifically plant breeders' rights, and it's quite a difficult concept to understand. What specific aspect of plant material are you protecting, and so on. And what can you actually do with plant material? I mean, there's a lot you can do. So going back to understanding, I think if you're in the agricultural sector, and if you enjoy science, I think there's always scope to focus on this area, and that's the beauty of it. It's always evolving, and that's the beauty of science and law to a large extent. So hopefully we find more young people interested in and energetic about contributing.
I think what's also interesting is just to take a bit of a longer look back, that plant breeders' rights are something that really only has developed in the last couple of decades. And prior to that, people didn't even understand what the concept meant. And if you think about the amount of resources and time spent on R&D to get to the point where you have something which is worth having IP rights about, it's quite something. Because if you think about the apple and pear and every other fruit you'll find on the shelf today versus what was there 50 years ago, I don't think people have any idea how things have improved. And if you were to take something from 50 years ago and put it next to what you have today, people, the average person, consumer, doesn't have that comparison.
Not just even 50 years ago. You can even go 15 years
Yes,
ago.
I mean, compared to take yourself, new varieties you've seen which have done so well here. I mean, blueberries. When I was growing up, you didn't really find blueberries. Blueberries was quite a...
They were frozen things
my
that
mind
came
was
from
always
elsewhere.
a European...
Yes.
You know, I associate Europe with blueberries. And now it's grown here everywhere.
Cherries too.
Yes, cherries too. So we've got science is always evolving. I think that's the beauty of it. And responding to it, making sure that's always where law is a little bit slow. It lags a little bit.
And then you add our government onto that.
But I think there is, I have to say, I obviously don't speak for the department, but I do think department, to a large extent, they do want to, they do need industry role players. They do need private companies' assistance. I can't do it all. And I think that also understanding the technicalities of aspects. I mean, even at workshops, it was difficult to get certain points across, but you need to hear from an industry. And that's why it's so important, like these public consultation events. You think, oh, it's just government driven. It's so important because otherwise, who's actually, these laws do impact us. If you're not going to participate, you can't say much about it, are you? So I do feel like people need to, in general, when you see a bill is coming out, I mean, like, you don't have to go and physically sit in Parliament and participate, but monitor the process. There's always written submissions can always be made, and you'll be amazed. They actually have an obligation to respond to these, not to each and every submission, obviously, but I need to consider. There's a ration. They need to be rational about it and need to consider at least.
It's always, I think, it's a thing with anything that's to do with government, with public participation, is that firstly, where do you send the bloody thing?
Yeah.
Secondly, is on whose desk? If you look at what was on carte blanche the other day of the state of the archive in Joburg, it is it's a horror story. So will it end up in one of those archives laying on the floor in a pile of, and will it ever be considered? So I think, speaking as a citizen, I think a lot of people are just...
It takes effort, let's face it.
Not just the effort, but why should I bother if it's going to end up there, for instance? And I think that is a big thing. But to add on to this, have you seen a change now with the new GNU government, with John Steenhuisen at the helm of it, with these kind of things? Has it become better? Is there more drive? Is it...
I think being good at communicating, I think that's quite...
that's you can definitely... And LinkedIn, they are
that's
very
for
active.
me, it's already a good starting point, communicating. But I think, for instance, I have a very good friend working as a state vet. And she always says you have to... I mean, the department is huge.
Yes.
There's actually a lot of people working for the department who do an excellent job. We always just focus on the political role players on the top. But there's so many who actually... go out of their way to make it function. And I think we shouldn't forget that part of the machinery. So we focus so much on the politics of what's going on. But to answer your question, I think communication has been much better. I think that's obviously, they want to, from a DA side, they want to show, they're taking action. But we'll see. There's a lot of still needs to be done. And I think I do take into account, I mean, a recent, I think, was it also reported on your profile, was it regarding like huge contract which Mr. Steenhuisen cancelled? There's a huge contract he cancelled recently, which was quite controversial, wasn't it? I might not get the specifics quite correctly.
It's ringing a little bell with me too.
It was it on a... Yeah, sorry.
Wasn't it grain testing? Something to do with
inspectorate.
Something to do with bread and grain testing?
Yeah, wasn't it inspectorate of it? It was something controversial. And so so it's definitely what we see from the department side. And that is good. But just getting back to your question, on you just send a submission, I would actually say a lot of people don't know this, but Parliament is an interesting place to be. I mean, obviously you've got a lot of interesting smaller parties in these committees they've got a specific agenda. But what you should never underestimate is Parliament has their own legal advisors as well, who are excellent at doing their job. And they also sit in on these committees and they provide advice to the committees. Remember, they look from Parliament's side, completely neutral position on, for instance, constitutional impacts of a proposed bill. And they gave excellent advice. What I would say is one voice is a lonely voice. You need to find your herd. And what we spoke about earlier before this podcast is our media and civil society. So you have a lot of organizations, even in the agricultural sector, who, they perhaps have a specific agenda, but they will represent a specific community. And I think you have to link in to these communities. If you feel passionate about a specific issue, you will find people. You will definitely find an organization who will be represented, or a media house. And I mean, you get excellent NGOs like Parliamentary Monitoring Group, for instance. They monitor what's going on in Parliament, and it's amazing the resources, but you just need to know about them. And actually, it takes a little bit of effort, but it's fascinating actually what happens. And I mean, you take a controversial aspect such as expropriation without compensation. I was a bit involved in that process. Firstly, it was so hyped up politically. But when it came to a constitutional amendment, what was actually going on in the committees, it was absolutely fascinating to hear different, and there's actually not a lot you could amend. There's a very specific one section only, which I proposed. And I think for the public, they often get a political version of what's going on.
Yes.
But actually our lawmaking and it's quite neutral, and which is
Okay.
If I can, there's a big difference between what's the machinery behind what's actually going on. For instance, I wasn't, this whole, when it came to a constitutional amendment, I think it was so hyped up, it was so politically charged, and people were suddenly so afraid. But if you understand from a constitutional perspective how very difficult it would have been to do that, to make that amendment, and how it could be tested and the limits of it, I think we've got a very, very strong constitution. And like we said earlier, and that's why your podcast is also so important, the freedom of the press. It's unbelievable, this protection we afforded, and I think people need to appreciate. We make it, ons maak dit af, baie vinnig, die grondwet. We still functioning as a country because of a very strong constitution. We still have the power to challenge and to challenge authorities in power. It might not, we don't see enforcement, that's a whole different issue, but that's not due to our legislative frameworks.
Cool.
That is an incredible comment you made there. Thank you very much.
I think we're gonna.
That's a lot.
She's gonna come back and tell us about that story.
But I think we've had an incredible discussion, and I think we can look to closing up. We have a closing tradition on our podcast, and that is where we ask a random question. Just a random question we ask you, and it's normally left for us by somebody else. And I have one, I think, which is quite relevant, and that is, why is it today that you do not find people who will volunteer to do something, like as in volunteering to be involved in local committees or to help with a local anything, school, church, community hall, or anything? People are a lot less civilly minded than they were expected to be previously. Why would you say that is?
That's a very good question. A question we can probably spend days and days to answer. However, I do actually find, I think if you go to certain pockets of communities, you often see on Kykenet how these farming communities have decided, listen, hierdie klein dorpie, we need to do it ourselves. We need to, the services we're going to attend to, and it's for everyone. Everyone's affected, and they all actually do it. It's amazing. They focus on a park and they rectify it and they make it beautiful again. Your potholes. So you do, I think it depends on where you go. But I think in general, it's probably a generational thing as well, is people are so focus on their own little worlds and their own, they do not, perhaps even COVID probably has an impact on it, being very, very isolated, not reaching out, not, focus on your work. You do your Teams meetings, your little world, and it
Social media echo chamber.
Yes, and I think it's so dangerous. Actually, who you listen to, like, you're obviously entitled to your opinion, but at least read a different newspaper, not the same newspaper, because people have kind of different opinions and different resources of reporting on a specific matter. So I think it's maybe that isolation, and also just seeing, maybe in our countries, not seeing, enforcement again, or what we touched on later. People don't see a government actually taking action. So I feel, okay, well, I'm not going to be able to make any difference because, I'm just one person. I think that's it's extremely sad. But you do find pockets of people actually saying, okay, listen, we have to do it ourselves. Otherwise, no one's going to do it. I think that's also a testimony again to the South African spirit. I think people, that's generally how we are built. And I think it's a positive. I get so discouraged when people are so negative about our country. Obviously, there are aspects you can go on about, but there are so many opportunities. There's so many opportunities in, if you don't find it, start your own business, do it yourself. If someone's not going to employ you due to certain circumstances or whatever, just start, do it yourself. Find and employ people. Focus on what you can do to contribute, not just sit and moan about the situation. So that's a very personal point of view, but yeah.
Well, it was a personal question,
Yes.
so thank you.
I've also got something. We had this discussion yesterday with people. We had to pick up one of my daughter's friends to come with us, and then the mama to come pick her up, and it was just the whole one. And I think we make our lives too busy for ourselves as well.
Yeah, that's also true. I've also got a kid, and I need to, you feel like at 5 I need to be able to read already, and I need to do this and that. And it's so ridiculous. I'm very sure when we were in grade 1,
Yes.
I can actually recall we weren't able to do anything. And we
Exactly.
were just sitting there. Till grade 2, we were probably.
But us
But
as
drive.
parents,
We're very competitive, and I think it's that's a whole
We're
different
caught up in our own personal things.
Yes.
But what you said about the South African spirit is very true. When called upon, when we are really need to, people do rise to the occasion.
Yeah, and I think that's also, it could have gone very differently, our situation after the elections.
Yes.
It was very,
It was fraught.
But I also, what I found very interesting is certain people were shutting down, didn't want to hear, about, we're just focusing on our job, our work, whatever the government's doing, that's not a South African attitude at all. I think that's, again, you have to participate, you have to be focus and at least just read what's going on. There's obviously a lot of violence being reported, crime being reported, but our politics are there for a reason, quite interesting. And in it, I think you have to participate. You can't just sit and moan.
Yeah.
That's a
Yes.
very personal point again.
Thank you so much.
Ach, dankie.
It's
It
been
has been very
incredible
It
and
was.
a lot of interesting stuff, which I think we can definitely explore again at some time. But thanks so much
So it
for
wasn't
coming.
too technical. I
No,
felt like
no.
I went
Well,
into...
Not at all.
For those who it was too technical, must listen to us.
But thank you again for your platform as well. It's amazing what you do, the work you do, and I think it's such a niche sector.
We enjoy it. We love it.
Thanks a lot.
Dankie julle.
Okay.